Welcome to the Probate Nation. My name is Richard Ruddy, and I am the host of the show this evening. People are living longer thanks to good health care and healthy lifestyles. But as we age, not everyone remains as sharp as they were earlier in their life. And frequently a loved one, a son or a daughter, is called upon to take on the responsibility of helping an elderly parent or family member with financial and medical decisions. Execution of highly recommended legal documents in advance can help you take care of that. But not everyone executes those documents, and when the time comes for you to help that loved one, you may need to take formal legal steps to get appointed to serve as a conservator and guardian, and in the process begin the living probate train ride. Our show tonight will look at the process in Fairfax County to be appointed the conservator and guardian of an elderly adult who has financial resources. This process begins with a petition to the court, a GAL investigation, a court hearing and probate office qualification, and continues with the ongoing oversight by the Commissioner of Accounts and others. We will also touch on some of the common problems and pitfalls that often arise along this living probate train ride. With us tonight are two elder law attorneys that guide us through this process in Fairfax County. Kimberly Murphy is a partner with the Fairfax City law firm of Hale Ball, Carlson, Baumgartner, and Murphy. She practices in the area of trust and estate litigation, contested guardianships and other related civil litigation, and has testified as an expert witness in many contested fiduciary matters. Kim is a member of both the National Association of Elder Law Attorneys and the Virginia chapter of that same organization, and is a frequent speaker at CLE programs for attorneys. Elizabeth Gray is a principal with the law firm of McCandless Lillard, located in Fairfax, Virginia. Elizabeth has been practicing law for 20 years and has extensive experience in the areas of guardianships and conservatorships. She is also a certified elder law attorney as well as a member of both the National Association of Elder Law Attorneys and the Virginia chapter of that same organization. Please join me in welcoming attorneys Kim Murphy and Liz Gray. Ladies, thank you very much for joining us today.
Thank you.
Well, the process, by which we get started, with getting appointed to a conservator or a guardian, really we have to kind of back up and ask ourselves, what are these documents that someone could execute in advance to mitigate the need for that kind of a court action?
For the guardianship, if you have an advanced medical directive, HIPAA disclosure, and a living will, you should be fine as far as not needing a guardianship.
Okay. And how about taking care of the money, which is what the conservator normally takes care of?
The money piece would be managed by, or could be managed by, a durable general power of attorney.
Okay. Do people also use revocable trust as a tool to also manage that money?
That's another tool in our box of options for surrogate decision making that we can use as a trust.
Okay, very good. Now, even if we have these documents, does that necessarily preclude the need for a conservator or a guardian? Or can there be situations where even with those documents we may still need to go to court?
Yes. Sometimes you do need to go to court. The document is stale or old. It doesn't have necessary information in there, or it's not working.
Okay. So we need to make sure they update our documents. Well, if we do need to go to court, if someone does become incapacitated and they can't make decisions or they don't have the necessary legal documents, what do we do? What do we do in order to get that authority?
So if there are no documents that have been executed, no advanced medical directive, no living will, no durable power of attorney, then the next of kin, the family member, would go to court with a petition and say, I would like to be appointed as guardian, which basically says that that person can make decisions for the individual, for their health care, for where they're living, what medications they should be taking, all those kinds of day-to-day decisions. And also a guardianship, a conservatorship, excuse me, which dictates financial. Okay. So anything financial decision-making, power over a checking account, what to do with mom's house if she moves out and goes into a nursing home, those kinds of decisions, and the court can make those decisions.
So those are our two options. Basically, these are a last resort options where the documents either don't exist to help us take care of those things, or they are not sufficient in order to accomplish what needs to be accomplished. So let's say we have to go to court and we need to go apply for a guardianship or a conservatorship. Let's talk about bonding. There is a formal process to request someone that be appointed a guardian or conservator, but I think bonding is a critical first step, and I want to ask you if you could talk a little bit about why that's important for a guardian and how that plays out, and why that's important for a conservator.
Bonding is the process where you agree that you're going to uphold the duties of a fiduciary in the guardianship case. In Virginia, the guardian is usually only bonded for $1,000 to $2,000, and it's not insured. There's no surety bond. It's just on your own honor.
So it's a personal promise to pay. And frankly, we were talking before, as we prepared for the show, that I don't think any of us have ever seen anybody actually sue on that personal bond as a guardian.
That's true. I've never seen anybody sue on it.
But how about the bond for the conservator? How does that come into play?
So for a conservator, if you think of a bond, think of it as an insurance policy. It is to ensure that the property, the money is spent appropriately, that it's spent properly. So bonding is a requirement when someone's taking possession of, let's say it's mom, that's the person who's to be incapacitated, taking possession of her checking account, her savings account, her personal property, her stuff, her real estate. And the bonding process looks into the creditworthiness of the individual who's applying. It looks into whether or not they were convicted of a felony, whether or not they had a bankruptcy in their background. And if any of those things show up, then that person may not even qualify to have a bond.
So it's important then, in almost all conservatorships require some level of a surety bond. And so before you even start the process to go to court, do we normally want to make sure that they're bondable?
Yes, you'd kind of want them to be pre-screened. You'd talk to a bonding company just to make sure they could even qualify, because it would be a shame to get through the entire process and then get to the courthouse and find out they can't get a bond.
That would be very troubling. Well, let's talk about the petition. There is a formal process to initiate that request, so just briefly tell me what goes into that petition to get this process going when we try to get someone appointed to be a guardian or a conservator.
So basically, you have to name the respondent. The respondent is the person that you're claiming is the incapacitated person. You also have to include a statement as to why this person is incapacitated. So you have to briefly state what's the issue. Do they have Alzheimer's? Are they forgetting where they're going? Are they getting lost? Those kinds of things. So you need that kind of a description. You also need to say to the court where this person lives. Are they residing in their home? Are they in a nursing home? Other things, you need to have a physician's certification that says that this person is incapacitated. Because the entire purpose of a guardianship, you're basically taking the respondent's rights and placing them in the hands of somebody else, their decision-making right into the hands of somebody else. Other things, statement of known assets, what does mom own? Where does she own it? That kind of thing. And then briefly state why you believe you should be appointed as the guardian or conservator.
Okay, but we do definitely have to have some sort of a medical evaluation as part of that process. We just can't go in and have someone say that, I just think mom can't handle it anymore, I think I want to be in charge.
Yes, because it's really a question of judgment, but it's not proper judgment, or what I believe is proper judgment. It's basically the absence of judgment. Mom's not capable of taking in information and making a decision based on that.
Okay. Okay. Well, we talked about guardian and applying for someone to be appointed guardian, and then we have this term called a guardian ad litem that shows up, and this person appears out of nowhere, appointed by who knows who, and a lot of folks are scratching their heads saying, I thought I was applying to be the guardian. So who is this person called a guardian ad litem that gets involved in this process?
Essentially, it's the court's investigator. This is the eyes and the ears for the judge, so that the respondent, the alleged incapacitated person, doesn't actually have to show up for court hearing. The GAL's job is to investigate all of the allegations in the petition and report back to the court the findings, the suitability of the proposed guardian or conservator, what the care plan is for the future, that kind of thing.
Okay, so they file that report, and again, they make their recommendations to the court.
Correct.
So we get through the process, we filed the petition, we've gone ahead and had the GAL do their investigation, they filed their report with the court and talked to family members and share that information with the judge. Now we're going to go to court for this hearing. Okay, tell me a little bit about what happens at the hearing. You know, how long does it take in Fairfax to get to court?
Well, in Fairfax, it's the quickest part of the whole thing. Don't you think?
It is. For me, I usually see the very contested ones, but the more, I call them simplified ones, you can get a hearing within 2-3 weeks of filing.
So you have to get the report in from the GAL at least a week in advance, but it does seem to go pretty quickly. Now, what happens when we go to court? You know, who needs to appear, for instance?
Well, in the petition, you would state whether or not the respondent should be there. If the respondent, which is the person who's the incapacitated, if that person, if it's not going to be harmful for them, they have a right to be there. So sometimes the respondent is there. The guardian ad litem is there. The proposed guardians are there.
Okay. How about the standby guardians? Do they need to show up as well?
I haven't found that necessary in Fairfax, but I oftentimes have them come along as well, or sign an affidavit that they're willing to serve as the standby guardian.
Okay, and so we go to this hearing. How long is the sort of simplified and sort of uncontested hearing? How long do they normally last? Because they're held on Friday normally.
That's
9
right.
o'clock usually is the uncontested docket. How long does that hearing normally last?
When asked for a time estimate, I usually say 5 minutes, and it really is very quick because the judge is prepared. He or she has read the GAL, guardian ad litem's report, and it's just a matter of signing the order.
Yeah, it seems to be that it's very, very efficient. Now, to come back to what you had mentioned, sometimes we show up and all of a sudden they become contested, okay? And contested means that people disagree, and so what happens then?
Well, if people disagree, then what happens on that Friday is the court decides that, all right, you all need to appear in calendar control to come up with a date. So everyone goes, picks a date, and that's usually a few months out unless there's an emergency.
Okay.
And if mom needs to be moved, if there's an issue with someone taking money from her, something like that, then that would force the court to give you an earlier hearing. But generally speaking, if it's contested, you get a hearing date 2, 3, 4 months out. It depends on how many days you need, whether the respondent has asked for a jury. If you ask for a jury, that takes time to get on the court's docket to have a jury impaneled. So a lot of it is it's a moving target, and it also depends on the scope of the contest and disagreement.
Well, we try not to have contests if we can avoid it, but people can disagree. But in the uncontested ones, okay, the objective at the time we apply is to get a court order entered. So when I get that court order entered by the judge that Friday, is the person who applied now in charge?
Well, there's one more step.
Okay.
You have to go down to probate to qualify. That's where you raise your right hand and swear you're going to uphold the duties of a fiduciary in Virginia, and you get your certificates of qualification. And that's really just a piece of paper that says you're the court-appointed guardian or co-guardian, and it's got the raised court seal.
So that's for the guardian, and then of course you get your conservative, and of course that's where, having gotten the bond approved in advance, we then know we can walk in because the probate clerk is going to say who's going to be bonding this, and if you haven't made those arrangements in advance, then you kind of go into a little bit of a lottery program as far as whether it's going to work or not. So we go down, we take our court order, walk out of the court in Fairfax, and we head down to the probate office. And of course, they do set aside some time on that Friday so they can pick up those cases coming out of the uncontested docket. We did talk about the fact that the bond needs to be approved in advance so we know that we're going to be bonded. Tell me, how is the amount of the bond that we actually need determined?
For,
How much
for conservator?
For conservator.
It's usually 1 year's worth of income plus 1 1/3 times the amount of property that the conservator is going to have control over.
Okay.
The real estate would be included if the court order gave them like power to sell.
Okay.
So if they were given the authority to sell, then that would also be included. The order dictates what the scope of power is. So a person is only allowed to take on so much assets that the court order says you can't take. So if the court doesn't give you power to sell mom's real estate, you're not allowed to sell it.
Okay, so and all that basically gets sorted out during the course of the GAL's investigation, then in consultation with counsel for the petitioner to figure out what really works, and then that gets into the order. So what is it that they get when they get qualified? What is this document called?
It's called a certification of certificate of qualification.
Okay, and they get one for as guardian, they get one as conservator.
Correct.
Yeah. Okay. Now, does the probate office, because we seem to have done a lot, and now I have this authority. It's like, now what do we do? Does the probate office give any guidance or any handouts of any kind? to
Sure.
folks?
They have a number of handouts that go over what you have to file, when it has to be filed, and what your duties are.
So I just mentioned to our viewers there's a couple of documents that we mentioned. One is a Virginia State Bar Guardianship and Conservator Proceedings that just talked about how you go about becoming a conservator or guardian of an incapacitated adult. There also is some instructions about filings you're going to need to make with the Department of Social Services, and these will all be posted to the Probate Nation website. And then our ever-efficient Commissioner of Accounts has a very extensive handout that talks about the various filings you're going to need to make with his office on an ongoing basis as you manage the money as a conservator. So we are now appointed. We're in charge. Now, to get from the beginning to this point in time, got to ask, who's paying for all this? There's attorney fees, for the petitioner. There's attorney for the GAL. Sometimes there might be a respondent's attorney for the respondent. Who pays for all this stuff?
Respondent, at the end of the day, the respondent's estate is looked to pay for all these fees. Mm-hmm. In a contested situation, that may not necessarily be the case, certainly for the guardian ad litem's fees and respondent's counsel fees. But petitioner's fees may be a question mark in a contested situation.
Okay.
Usually it's not an issue in an uncontested.
And then if you have somebody that's considered indigent, like a special needs child turning 18, then the Commonwealth of Virginia is going to pay the costs for the guardian ad litem.
And that's very helpful. And we have a number of those. Now, I know that there's a lot of ongoing reporting requirements. Certainly coming out of the gate, we have to file some documents with the Department of Social Services, and that has to be filed pretty promptly. How soon after we get qualified do we have to do that?
You have to file the conservatorship inventory in 6 months, covering the first 4 months.
Right.
And
that's to the Commissioner of Accounts.
That's to the Commissioner of Accounts, and that's on the conservatorship.
Sure.
For the guardianship, you also have to file your first report telling the Department of Social Services what you do, what you've done to help the person, and what the situation is with them medically and psychologically and socially.
And that's the annual report that you then file each year.
You're right, and then it becomes annual.
Okay. Okay. And both those forms will be posted to the Probate Nation website, but those are part of the packet of information that's handed out when you come out of the probate office. Well, let's turn to, just given the fact that your extensive experience, I would really like you folks to share some of the common problems and pitfalls that you have seen when people make a request to be appointed a conservator or a guardian, and frankly, once they get appointed, things that they trip over. So I'll give you guys a chance to share some of your insights.
Well, in my line of work, where things are contested, the things that trip people up are not acting together. They act unilaterally. They're not being secretive, not telling their siblings what their plan is with mom or what's going on with mom. Not having meetings, not giving out total transparency. It's amazing how much trouble you can start by just saying, I'm in charge, don't ask me questions. Not discussing matters of significance about mom's health, what mom's doing, taking mom out of the nursing home and not telling anybody that that's what you're doing. All of these actions cause problems and will shove you into a contested situation. And most of the time, they could have been avoided if you had just talked to each other.
And that probably can be true also in the context of even filing the petition itself, is making sure you communicate. Liz, how about anything you might observe?
Sometimes it's the respondent or alleged incapacitated person who doesn't want the guardian appointed, hasn't signed any documents, but they're contesting the petition. And those are difficult as well.
Sure. So we really do have to communicate. Well, you know, there's a lot that's going on here, and a lot of moving parts. A lot of times you can't control all those things. We've covered a lot of territory. I wonder if you guys can share some of your closing comments and suggestions with people about things that they should do, they shouldn't do, or things they should watch out for once they've been appointed.
Well, certainly once someone's been appointed, making sure that you follow what the court order says. Understanding that you are managing somebody else's money. So the decisions that might have been okay prior may not be okay now. For instance, if mom used to give out large gifts in the past, is it appropriate for you to be doing that now, particularly when it comes to yourself? Should you be giving out money spend money the way she did when she's got limited assets and she has care needs? So these are all the types of decisions that you should really be watching out for.
Okay.
Prior to filing, it's a really good idea to try to work things out before you go to a court. Courts are funny. There's a winner and there's a loser. And 9 times out of 10 in a contested matter, the attorneys are being paid a small fortune to fight out some of these things when the best solution could be found between the family members.
I couldn't agree with you more. Liz, how about yourself? Some closing suggestions and comments.
Planning ahead is always a really good idea. It's amazing how many times we have to go to court to do a guardianship and conservatorship because the family didn't get their documents in place ahead of time.
Okay. Well, I tell you guys, this has been a great conversation, and I want to thank you so much for taking the time and coming and visiting with us and sharing this with the public. It's a great public service, and we're deeply indebted to you for doing so. Thank you very much.
Thank you.
You're very welcome. You know, our population continues to get older every day, and with the passing of time, many of our elderly are no longer able to make good medical and financial decisions for themselves. There are several recommended legal documents that could be executed in advance to allow you to pick someone to make decisions for you when that time comes. But many seniors have not taken advantage of that planning opportunity, and as a result, a living probate called a conservatorship and a guardianship becomes necessary. As the discussion with our guest today illustrates, there is much that will need to be considered and done to file and successfully prosecute a petition for a conservatorship or guardianship, beginning with working with the family, filing the petition with the court, preparing an appropriate court order and having that order entered by the court, getting qualified in the probate office, and much more. This can and often is a complicated process, and certainly is not a fill-in-the-blank kind of legal proceeding. We strongly recommend that you seek the advice and assistance of an attorney who has experience with adult conservatorships and guardianships should you need to take the living probate train ride. This brings us to the conclusion of our show today on adult conservatorships and guardianships in Fairfax County. Hope you found it informative, and remember that replays of the show can be viewed on the Probate Nation website. On behalf of the Probate Nation, thank you for visiting with us.